Okay. Good evening. Welcome to the Tuesday, April 12th meeting of the Hamilton Zoning Board of Appeals. The matter before us is the petition submitted by Harbor Light Community Partners, 283 Elliott Street, Beverly, Mass., for a comprehensive permit pursuant to MGL Chapter 40B for the construction of a 45-unit multifamily housing. The property is located at 466 Highland Street, Assessor's Map 28-8, Lot 1, zoning District RA, and is owned by the Britton Family Trust, LLC.
So where?
Couple of matters before we really get underway. So our members, David Parent-Chief and Andy Phillip, are joining us by Zoom. Andy was not able to be with us when we opened the hearing on April 6th, but I believe she has watched the tape of the April 6th meeting prior to this meeting, so under the Mullen rule, she can participate in the hearing going forward. Just for the record, Andy, you have watched the tape, is that correct?
Yeah, it says that.
Andy, can you hear me?
Do you want me to stop video, or what do you want to do?
Joyce.
I'm gonna mute.
Andy's up top there.
Yeah, Andy?
Oh.
I see her.
She's muted.
Can you hear me?
She's muted.
Can you,
There.
Andy? Andy?
Patrick, you muted me. I can't be muted on the sidebar. I'm not gonna be hearing anything. Go to the side, yeah, HWPM. One more, right. Unmute. Kevin, we're muted for some reason. I don't know why. Hit that. Just do make co-host. That's easier. Yeah. Okay, Kev, you gotta unmute. Unmute me.
Can David hear us too?
Right now, Phil.
Okay, David and Andy, can you hear me?
I can hear you and I'm unmuted.
Okay, Andy, you watched the April 6th meeting prior to this meeting, is that correct?
Yeah.
Okay, very good. Okay, the purpose of this meeting, the sole discussion will be under the Chapter 40B. If there's once the hearing has been opened, there's a 15-day opportunity for if there is a safe harbor available to the town, there's a 15-day period that the board must assert that. So tonight we will discuss whether there is in fact a safe harbor, and secondly, if there is, whether we would want to assert it. That's the sole thing that we'll be dealing with tonight. So we'll start with, this issue was raised by council for abutters at the April 6th meeting. And so after that, Patrick Reffett, who's our planning director, has had some correspondence with DHCD. Also, there's been, so that correspondence and some correspondence from the abutter, and correspondence from the applicant and other correspondence is part of the record that can be viewed. So we'll start with Patrick Refit summarizing his back and forth with the DCHD on this issue.
Yeah, thank you, Bill. I had contacted DHCD at the in response to the point that came up from the abutters attorney. It might be better if I read this very short email that came back from a gentleman named Philip DiMartino. He's the staff planner at the Department of Housing and Communities and Development at the state. And again, I made the request regarding the potential for the town pursuing safe harbor. His email to me reads, "Hi Patrick, per your request, DHCD has reviewed Hamilton's request for housing production plan certification. The letter came and corresponding documentation received earlier today, April the 11th, 2022, includes the Willow Street project, which became SHI eligible prior to 2022. Parentheses, initial SHI eligibility occurred no later than April 2021 when the building permit was issued according to the information provided. Thus, the Willow Street project is not eligible for housing production plan certification in 2022. The April 11th, 2022 housing production plan certification request also included Asbury Street, a comprehensive permit project. The units appear eligible for the subsidized housing inventory, but the comprehensive permit issuance initial SHI eligibility date is November the 2nd of 2021, so it would not be eligible for housing production plan certification because the certification request was not submitted during the 2021 calendar year. I have included an email I sent on April the 7th, 2022 that details the requirement of HPP certification. The email notes that the units must be initially eligible for housing production plan certification in the same calendar year for which certification is requested. Please note that DHCD has 30 days to issue a certification determination letter. Any questions, let me know. Phil DiMartino. So that was the response that came from the state. I do want people to be aware that the town will be pursuing having all of the units on the subsidized housing inventory when they qualify for that. That's not possible right now because at the Willow Street project, those units aren't finished yet. And then, as everyone's aware, at that
Near where our doctor used to be.
40B project that was permitted by this board in December, it hasn't even begun construction yet. So those
Are you muted?
both of those projects will be certified. We're focusing now on safe harbor issues.
Thank you, Patrick. Since it was raised by counsel for the abutters, is there anything the counsel for the abutters would like to comment on or say in response to that?
Yes, good evening, Mr. Chair and members of the board. This is Dennis Murphy. I'm not sure everybody can see and hear me.
please mute your phones and screens if you are not speaking.
May I proceed?
Yes.
Again, it's Dennis Murphy. I'm counsel from Hill Law on behalf of the abutters group that raised this issue. And the first thing I just wanted to point out is that I sat in your shoes on the ZBA of my own town for nearly a decade, which is how I came to be in the 40B world, and dealt with a number of issues like this. And I can tell you there is not always a clear answer under the law. And the one thing I know about 40B is that there are very few things that favor a municipality, and the safe harbor happens to be one of them. The way the regulations work is that if the board elects not to invoke this safe harbor, it's gone forever. You'll waive it. And so my first point is that if it's unclear at the end of the evening whether or not it's applicable, what I would suggest is in many other towns, and I believe your town council is George Pucci. We had one of these a few months ago in Walpole, same exact issue, HPP certification, and there the ZBA invoked it. If there's any doubt, the default ought to be that the board reserves the town's rights under safe harbor rather than waive them. I actually don't think there's ambiguity, and I'll speak to my own issue, Attorney Timon's letter, and that recent email you got from the gentleman from DHCD in order. So the Harbor Lights project was a site plan approval, and that was in December of 2019. The issue of whether it was a site plan approval or a 40B is really irrelevant, although the lawyers talk about it in the letter, because more than a year transpired between the site plan approval in December 2019 and the building permits in April of 2021. Under the rules, and I'll read it to you and cite it to you in a moment, under the rules, when it's been longer than a year, there's a lapse and it becomes ineligible. And I'm looking at 56, let me just be clear, 760 CMR 56.03 4F, and I'll just read you the sentence that's 3 lines down.
Are you there?
I'm sorry, I'm looking at the wrong place. I gave you the wrong site. I want to read from 56.03 to C, which says provision on time lapses. If more than 1 year elapses between the date of issuance of a zoning approval under Chapter 40A and the issuance of the building permit, it will become ineligible for the SHI until the date the building permit is issued. So for Harbor Lights, it was not eligible in 2019. It became eligible less than a year ago, April 22nd, 2021. The other project, the 10-unit one, that one I don't think there's any debate. Those units became eligible November 3rd, 2021. There's about a 6-month period of time between them, between April 22nd and November 3rd, 2021. The regulation states that the town may request certification at any time. And it's that I'm citing to 56.03 section 4F, and it literally says what I just quoted: requests for certification may be submitted at any time. And it goes on to say later in that same provision, the certification is effective on the date upon which the municipality achieved its numerical target. In other words, certification is retroactive to the date when the town met its HPP, and by HPP I meant housing production plan. I think everyone agrees that to make a 0.5% progress under the housing production plan, you needed 14 units within the same 12 months. And let me be clear about that. It doesn't say year, certainly doesn't say a calendar year. It says during the 12 months prior. So imagine, if you would, instead of talking about approvals in April and November, we had one on New Year's Eve and then one on New Year's Day, a day apart. You're telling me that I can't get HPP certification even though they're a day apart because they're in different calendar years? That's a ludicrous interpretation and not correct and not consistent with what the regulations. I think part of the reason that
All right, I'm listening to you.
DHCD email may seem
how you doing?
misleading is that it was not done based on a full application. It was done by email with very little thought. They ordinarily take 30 days, and I disagree with that. My second point that I wanted to just highlight is that under these regulations, and I'm going to give you one more cite and read one more thing. The board and the developer don't have to make this an adversarial process. You as a board can say, don't make us waive our rights. We don't know if we have safe harbor. We're going to submit a real application. DHC has 30 days. They'll make a determination. Maybe we do, maybe we don't. We'll live either way. Go ahead and make your pitch. We'll hold our hearing. If we like your project, we're going to vote for it. If we don't like it, we'll vote a different way, or we'll add conditions. But the one thing I would caution against, because I don't think we're going to get certainty tonight, is just waive this. And I'll just read that 56.031, the very last paragraph say, board may, sole discretion, elect to proceed with the full hearing and ultimately approve a comprehensive permit, even though one or more of the above grounds, which are the grounds for safe harbor, have been met. So the bottom line is, don't waive it. If DHCD says you have it, great. If you don't, you don't. Either way, we go on to hear the merits of the appeal. There is nothing that compels either party to be adversarial. The certification would make no sense because it says that requests for certification can be made at any time, and they're retroactive to when they became effective. You know, poor Mr. Rafferty, who's got enough to do, would have to check constantly to see if we were in safe harbor and make these repeated requests. That's not the way the rules work. They are complicated. I believe there is a safe harbor. I can't tell you for sure. I know both town council and Attorney Timon. I don't know that either one could tell you for certain that there isn't safe harbor. And for that reason, I suggest that you reserve the town's rights and invoke it. Thank you.
Thank you. Next, we'll hear from the applicant or counsel for the applicant.
Hey, Mr. Chairman, Andrew DeFranza here. Nice to see everybody. I'm in my own board meeting across the hall, so I jumped out to say hello. I think you have our letter from Mr. Timon. We obviously disagree with Mr. Murphy and his colleague, Mr. Hill, on their position, largely because there is no certification of the plan as Mr. Timon relayed in his letter. I also think there certainly is a question of good faith and the spirit of intent of the rules. And when these buildings or projects, none of which are done yet, as was mentioned earlier, were brought forth. This is, I think, in my experience, the third or fourth housing production plan that the town has initiated, and it's a good one. But certainly, whether or not a project that was started in 19 and one late in 21 should be considered to be in the same calendar year, the same 12 months, seems highly debatable. But I think the core issue is the certification, and you have that in our letter, and we would encourage the board, excuse me, not to invoke safe harbor. Thank you.
Trying to say that was.
Thank you. And we'll hear from Philip Pucci of KP Law, who is a special counsel for the board regarding this matter.
Good evening, Mr. Chair, members of the board. George Pucci from KP Law. Good to be with you this evening, and I want to commend Patrick has done quite a lot of scrambling and work since the first hearing session to try to do some due diligence and get up to speed on this issue of compliance of the housing production plan, which would, if that was certified, it would enable you to declare that denial of the project or conditioning the project would be consistent with local needs as a matter of law. So I just want to just repeat some of what was said, because this stuff is really complex, and I kind of want to just orient you to where you are. Personally, and I've been practicing for 32 years. I've been doing land use permitting work for 22 years now, and specializing in 40B over about the last 10 years. So I just want to mention that I have to agree with Attorney Murphy. Oftentimes the regulations are very difficult to read and interpret. They're inconsistent in places, and then we don't always agree with rulings from DHCD or opinions regarding these types of issues. And the reason I talk about my background a little bit about experience with 40B is, personally as an attorney, I hate the term safe harbor. You know, it's not mentioned anywhere in the statute or the regulations, and it kind of implies like affordable housing is this terrible thing, and if you get quote unquote safe harbor, you don't have to grant any. And that's the reason I try to orient boards back to what you're talking about is the ability to deny a project or to condition a project without an applicant's right to appeal to the State Housing Appeals Committee if you've met certain statutory minima. So a lot of times people hear, you know, if you've got 10% affordable housing in your municipality, you can declare that denial of a comprehensive permit application would be consistent with local needs. And so that's kind of what this term safe harbor really means under the statute and the regulations. And so one of those statutory minima, another one you may have heard of is when you've got a certain land area that's occupied by affordable housing. If you reach a certain percentage, you can make this declaration, similar to here what's being asked of you tonight. Another one, which is a little bit more arcane, is certified compliance with a housing production plan, an approved housing production plan, which Hamilton does have. I want to just clarify that There's a lot of what both the applicant, his attorney, as well as the applicant tonight, I don't know if he's still here, I hope he is still listening in, that they say that is correct in terms of their interpretation, that it's a reasonable interpretation that they're putting forth. And then Attorney Murphy makes some valid interpretive arguments concerning the regulations, and I just want to kind of key you into those. So what the applicant had referred to is, you don't, as of now, when you open the public hearing on this, have actual certified compliance with the approved housing production plan. That only comes after a process where your planner or somebody from the town requests official certification that you are in compliance with the housing production plan. The issue that we're talking about tonight is whether you got the necessary proportion percentage during that calendar year last year. So we're talking about 14 units. Whether there were 14 units eligible and added last year in that calendar year that would enable DHCD to certify your compliance for that year. If you have the certified compliance, then it applies for a year. It puts you into this situation where you can deny or condition a permit as consistent with local needs. So what the applicant very correctly referred to, and it's in his counsel's letter, is 56.03(1) subparagraph B, right at the beginning, talks about one of these statutory minima that you can declare was the so-called safe harbor for, is in the instance where the department, referring to DHCD, has certified the municipality's compliance with the goals of its approved housing production plan. So that very clearly, states pretty explicitly that you're not in that zone of safe harbor unless and until the department has certified the compliance, and you don't have that right now. You don't have certified compliance with the housing production plan. But, as Attorney Murphy pointed out, when you go later in the same section of the regulations in 56.03, it talks about this certification process of compliance with your housing production plan. And that's in 56.03(4)(f), as in Frank. And where it's inconsistent is it says there, and what we're talking about is when a municipality has increased its number of SHI-eligible housing units in an amount equal to or greater than 5% production goal for that calendar year. So we're talking about 14 units here. It goes on to say, requests for certification may be submitted at any time. And then it says, if the department determines the municipality is in compliance with its HPP, the certification shall be deemed effective on the date upon which the municipality achieved its numerical target for the calendar year in question. Then it says the certification shall be in effect for a year. So if you follow that language, I would have to agree to the soundness of Attorney Murphy's analysis that implies that if
Patrick, we lost HW Cam.
If
We
those
can no longer hear.
if those SHI-eligible units qualifying you on this 5% production occurred in 2021 calendar year, you don't have to request the certification in the 2021 calendar year for that to
Patrick.
apply. If you get that certified now, according to the regulation, that certification shall be deemed effective on the date upon which the municipality achieved its numerical target, which clearly refers back to whenever you qualified. In other words, when those units came online in November or December of last year. Then if you receive that certification, that should be available for a year under the next sentence of that regulation. So it's very hard to follow this unless you have this and you're scrutinizing it. And I hope I'm giving you a reasonable digest of what we're talking about here. And And then last but not least, so then the other ambiguity comes up, aside from these issues about, do you need the certification when you invoke the so-called safe harbor? Can you get the certification outside of the calendar year where you added the 14 units? And if so, does that relate back, and does it then apply that it's available to you now? Then the last ambiguity here is it talks about when units become eligible for the SHI, as SHI eligible units. That's ambiguous as well, because it talks about with 40, if it requires, for units that require a comprehensive permit or a zoning approval under Chapter 40A or completion of plan review under Chapter 40R, the date those become eligible is the earlier of the actual time the permit was actually filed with the municipal clerk, or the date the building permit issued, or occupancy of the permit and other provisions. So those units that you're talking about, not the Habitat for Humanity units, but those ones earlier in the year that there's the ambiguity, they don't seem to be addressed in this, about when you would actually kick in that, of what year those came online for you under these provisions. I think Attorney Murphy does give a cogent interpretation of it, is if they were originally permitted
Patrick,
in
we've lost audio again.
2019,
Cannot hear Attorney Frucci.
if they were originally approved in 2019, they lapsed after a year without issuance of a building permit, then they did not become eligible again until those building permits issued in April of 2021. In which case, then you would have 14 units in 2021 that you would have a reasonable ground to assert that denial of the project would be consistent with local needs. So both the applicant and the abutters definitely have valid interpretations of these regulations. And I just want to point out, with respect to DHCD, I handle appeals of DHCD rulings, and we litigate those, and I have some pending in the Housing Appeals Committee and various issues. So it's an interpretive type of thing. It's not disrespectful to disagree with DHCD. There's a process for appeals of decisions. So the fact that DHCD might have, rendered an opinion on something does not necessarily mean that you're bound by that. And then the final thing, and then I'm available to answer any questions and break it down in terms of details. So in the event you do choose to invoke that denial of the project or conditioning it would be consistent with local needs under the statutory minima, I've provided a draft motion in that regard. Then the next step, in the event that you did that, you have to provide written notice to the applicant and to DHCD, also within 15 days of the opening of the public hearing, which has already occurred. The applicant then has the right to appeal that to DHCD. DHCD then has 30 days to issue a decision on that. At that point, if DHCD rules against you, you have a right to appeal to the Housing Appeals Committee. Same thing on the other side if the applicant got an adverse ruling from DHCD. And the other alternative, another one that Attorney Murphy pointed out, is whether or not you have this legal ability to invoke consistency with local needs as a matter of law, you can always go forward and hear a comprehensive permit application. And once you do that, though, you have to do it under 40B. You can't then pick and choose how you're going to regulate the project. You would have to exercise jurisdiction the way you would under 40B. So I'm just hoping that that brought you a little bit into, oriented a little bit on it. I would say it's definitely correct. If you do not invoke within the 15 days of opening the public hearing, you have waived that. Even if you then go back into safe harbor or have other grounds to assert it, once you've waived it, and you're in for the ride on the full comprehensive permit application hearing and then issuing a ruling. And a decision, if the applicant was unhappy with it, would then be subject to appeal to the Housing Appeals Committee. So hope that orients you a little bit, and I'm available for any questions.
Okay, before you step away, first, for some reason, I keep calling you Phil instead of George.
Not a problem.
I
like the name.
apologize. I apologize. Call me anything but call me, as someone once said. So I did, well, I neither the Select Board nor the Hamilton Affordable Housing Trust has opined on this project one way or the other. So I guess my question is there a reason, assuming we could invoke safe harbor, is there a reason to invoke safe harbor? I'm talking about, you know, on a 30,000 foot level, other than that you've decided, well, we've got enough affordable housing this year, and you're kind of prejudging the project.
It's sort of halfway that's correct, but the other the consequence of it as well is if you invoke it and then you end up that you go ahead and hear the application, or you get an adverse ruling from DHCD and you decide you're not going to appeal that, you're going to go ahead and hear it. The only thing about invoking this ability to declare that something, denial would be consistent with local needs, is that preserves your ability to possibly not be in the position of defending an appeal at the State Housing Appeals Committee. So the Housing Appeals Committee, some municipalities find it quite notorious. They're very developer-oriented. They tend to rule in favor of proponents for affordable housing more often than not, and it's a very difficult forum. So that's something that's a big consideration for municipalities. If they can avoid being subject to appeal to the State Housing Appeals Committee, they may do anything within their power to try to do that. And if you have a valid safe harbor, that valid invocation that is then in effect, that would enable you to avoid that appellate process to Housing Appeals Committee. So so let me give you a hypothetical answer. You invoke consistency with local needs under the compliance of the housing production plan. The applicant chooses not to appeal that. And then you decide you're going to go forward anyway and hear the application. In that event, then the applicant has waived the right to go to Housing Appeals Committee on your ultimate decision. So then, even though you'd exercise 40B jurisdiction over the project, your conditions of approval would not be subject to appeal to the Housing Appeals Committee at that point, because you'd have that consistency with local needs preservation. So that's really where it comes in.
So there might be something.
Yeah. One thing specific to your point, I wanted to make that point, but specific to your point, yeah, other municipalities may feel differently, that they do feel like they've made such efforts toward affordable housing in their particular municipality that they want to be assertive in their ability to invoke consistency with local needs. So and sometimes, quite frankly, a municipality doesn't like a project. They think it's poorly planned, comments on it pre-application have been ignored, issues like that. Sometimes that comes into a municipality's head, and they want to assertively explore whether they can declare consistency with local needs.
Okay, thank you. Okay, I guess we can, I think so. We got four folks have spoken, 4 positions. We can begin to discuss, and let's start with, are there any questions for any of the speakers from members of the board?
I just want to clarify real quick. So we produce the current housing with the Habitat for Humanity, but we do not have the certificate of compliance. We need the certificate of compliance in order to see if we meet the percentage regulation to invoke safe harbor. And then we invoke safe harbor, but we still have to then come back and review this in another year. Is that basically sums it up where we're at?
I was going to stay here, Mr. Chair, but through you, I answer questions.
Yeah, we want to be efficient with our time here, so if Mr. Pucci can, he doesn't have to go through the chair on every question, so.
Yeah, good evening, David. Well, I mean, that goes back to that interpretive question, is that the applicant, pointing to one section of the regulation, says you need that certification in hand to invoke it. The other interpretation that I just read, consistent with Attorney Murphy, and the language is pretty clear from Section 2F, that you can request that certification at any time, and if it's certified, it would relate back to the date that you qualified. So it would relate back to when the Habitat for Humanity units came online. So
we would still end up, though, we would be delaying the project, but we would still be having to come back and revisit a housing project later.
Oh, yes, yes, depending on what happens,
Okay.
right, you can go in and out of it. Correct.
Okay.
I'm gonna just stand here.
Yeah,
Mr. Chair,
I think
but-
that probably is most efficient. Andy, do you have any questions at this point?
I do. Attorney Pucci, I think last time you mentioned the 14 houses, the 14 units weren't, there are other qualifications. Can you talk through some of those other qualifications and if we need to be discussing those, or is it really just the 14 that we want to focus on right now for the conversation?
I think probably it would make sense to focus on the 14, whether you had 14, at least 14 units that came online in 2021, and assuming you did, then you still have the interpretive question that you would have to address of, all right, well, still, we don't have it certified as of now, but are we still able to invoke it, get the certification subsequent, and then it would relate back to the date the last units came online. But I think your best focus would be probably on those, whether you hit the 14 units in 2021.
Wonderful, thank you.
Stephen, you have any questions?
I'm just, Attorney Pucci, I'm curious, if it sounds to me like there is the benefit that if we were to certify and invoke that, we could then hear the petition, go through the entire case, approve it, and if we had conditions of approval, they wouldn't be able to be appealed. That sounds like something that it benefits the board. Are there any things that do not benefit the board going through that process?
Yeah, the only thing that would come up is something would happen in the interim. So if you invoke it tonight, and then the planner provides the requisite notice to the applicant and to DHCD, the applicant has the right to appeal that to DHCD. If DHCD rules against your invocation and says you shouldn't, you're incorrect, and here's why, then you would have to appeal that. Otherwise, that would be binding on you. So then, if you go forward, if you get an adverse ruling from DHCD, and then you choose not to appeal, and that appeal would be the Housing Appeals Committee, if you choose not to appeal and you choose to go forward with that comprehensive permit application, that opinion would be that decision would then be binding. So later on, if the applicant was unhappy with your conditions of approval, you would be subject to an appeal to Housing Appeals Committee. The one thing that I should tell you too is, if you're not inclined to end up in this would be something to determine when and if DHCD, when and if you invoke it, and then DHCD rules against you, whether or not to appeal, because where a significant delay would come in is during this initial process, the hearing would be stayed, told. Your 180 days for completing the public hearing would be told. so that time doesn't count. If one of the parties, though, appeals an adverse ruling from DHCD, that goes to the Housing Appeals Committee, and then your hearing is stayed. And that process can take a year to 2 years, even on a simple case. So you can't go forward then. The applicant can't go forward in the event of that appeal while that's pending at Housing Appeals Committee. But that would only occur if either of the parties appealed DHCD to Housing Appeals Committee.
And both parties can appeal on the decision of whether to invoke.
Yeah, if you invoke you would notify DHCD. The applicant has the right to appeal your invocation to DHCD, and then DHCD within 30 days will rule on it.
But they don't, so they would appeal the application, not the decision,
They would appeal the declaration,
our declaration.
yes. Typically, applicants, in a lot of cases, if that declaration is made, they tend to say, well, we don't want to go forward, we'll end up appealing it. And that's what can happen. So those are kind of, various scenarios that could occur.
Thank you.
But again, you have that ability to cut off that lengthy process in the event of an adverse ruling from DHCD. You don't have to appeal that, so.
Bruce, any questions?
Well, I guess, it sounds like we have two projects that are kind of, we're sort of trying to account towards the 14, right? We have the Willow Street, and then the one we just approved this last fall or November, whenever it was.
Right.
Up on Asbury Street. If those are the only two, can't we kind of look at each one and figure out where it's gonna fall? I mean, one's still in construction, I guess, hasn't been occupied yet, the Willow Street. The other one hasn't even started yet.
Right, but that wouldn't be the date that this kicks in. Like, say, just take the Habitat for Humanity, because there's no ambiguity about it. It was a 40B, all the 10 units would count. The only ambiguity there is if you didn't request certification in 2021. So if you were to request the certification now, under that first part of the regulation, it says you needed to get it in 2021. So you're too late to invoke safe harbor on this particular application. So that would be for the Habitat for Humanity units. The other ones are more ambiguous because that kicks in with Attorney Murphy gave you his interpretation of how that would work. They were originally permitted in 2019. That permit lapsed because building permits didn't issue within a year. Then those only became eligible to become shy eligible units when the building permit issued in April of 2021.
Which units are these now?
Say that again.
Which project is this?
That is what project?
Willow Flats, 59 Willow Street.
Okay, on Willow Street.
Yeah, 18 units, 9 of which are deed restricted.
Okay.
Where kind of some confusion now comes up is in the uniqueness of this is when safe harbors kick in because something comes online as a shy eligible unit, if the building permit doesn't then issue within a year of that approved project, then that can take you out of safe harbor. So where some confusion I think could possibly come in on this is the 1 year building permit issue is being kind of looked at in a different context with that project. I apologize, I forget the name of that project every time.
Willow Flats is
Willow
what
Flats.
it's called.
Where this 1 year lapse issue comes up with that is they were permitted in 2019 to be shy eligible, to remain shy eligible, the building permit had to issue within a year. It didn't issue within a year, so those units lapsed.
So when
in
you say,
terms of
when you say permitted, and then you said the building permit, it was permitted, but then the building permit wasn't pulled in a year?
Correct. The building
Or
permit
was it
has
the meeting?
the building permit has to issue within a year for them to remain shy eligible.
Yeah.
So what Attorney Murphy is arguing is those became ineligible when more than 1 year passed without the issuance of a building permit. But those remain potentially shy eligible units. Then they became eligible again when the building permit issued in April of
The following.
2021.
Yeah.
So he's arguing you count those units in 2021 along with the Habitat for Humanity units. Even accepting that, though, you still have to remember the applicant also has a valid argument on that first part of the regulation I read to you, that certification has to be issued in that year that they came online. I don't love that interpretation, I have to be honest, because to me it really doesn't make sense. If you became eligible, you should be eligible, and the certification should relate back, just like the other part of the regulation provides.
Right.
Any questions at this point from the board? Are there any questions or comments from members of the public on the very narrow issue of the safe harbor? Okay, I'll take that as a no. Well, I can tell you what I think, but why don't we hear from, we'll start with Andy.
I'm inclined to not invoke.
Okay. Stephen?
It seems that there is I'm sympathetic to the argument that it gives us more options than removes options from us. So under that, I would be inclined to invoke, I believe.
Okay. David?
I would want to hear more arguments between Mr. Murphy and the city's rep and the rep for the project, because the back and forth between the interpretation, I want clarification on the units that have been built and if what's possible, or if we can do something before we start pushing forward with another project that's going to either, one, be delayed, or two, get kicked down the road for a year and a half, and we're going to be back revisiting this in a year and a half or 2 years whenever the appeals and everything go through. I don't feel we have enough information to make a sound decision. I think we're teetering between 2 points of view without a solid foundation on the current numbers that we're eligible for.
Okay. Bruce, any?
Yeah, I feel exactly the same way. I think just understanding, we only have 2 projects we're talking about, just getting a better grip on.
So you're looking for more information at this
Yeah,
point?
yeah.
Okay. Okay, I guess my initial feeling was that to not invoke safe harbor, because we do have as I say, well, the town hasn't other town boards haven't weighed in one way or the other, but there's, we do have sort of a obligation isn't quite the word I want, but we are supposed to be pushing forward towards affordable housing, and the fact that we might be able to delay something wasn't a selling point in the grand scheme. I'm talking about not about this particular project, but just sort of, again, at the 30,000 foot level. However, hearing that there could be a little bit of a give us, the town, a little bit more hand if we invoked it. That might change my position. So at this point, the board's seems to be a little bit, as a whole, is a little uncertain. So I'd hear from both the applicant and the counsel for the abutters if they want to add anything that might change this, shed some light on this mystery for us.
Mr. Chair, if that's an invitation, I'm happy to take it. You all have heard from your own town council, Attorney Pucci, and the one thing that we share is that everyone who looks at these same regulations finds them very complex and difficult. So let me see if I could take another stab at trying to simplify why I believe Hamilton is in safe harbor based on the two projects. So let's start first with the Willow Flats. And that was a site plan review that was finalized in December of 2019. On that date, it became eligible. Those units were eligible to be added to the SHI. Nothing about this is self-executing. The units don't go on the SHI automatically. The town has to actually submit a form to make them. So that's why it's when they're eligible. So they're eligible from December 2019, December of 2020, by operation of law, they became ineligible. So a year lapsed and there was no building permit. Then in April, 4 months later of 2021, April 22nd, there was a building permit and they became eligible again. So those units count. They're not yet on the SHI, but they are eligible and they should be there. That's the Willows. I don't think there's any debate that you only need these two because you need 0.5% and 14 is the magic number in a 12-month period. It's not a calendar year. Nobody would ever get there if it was in the same calendar year. The Habitat project, that's a simple one. When you approved that comprehensive permit back in November of last year, it became eligible for the SHI. Those two projects are only 6 months apart in the same calendar year. One was building permit, April 1. The other was the comprehensive permit, November of 21. Together you add them up, you have more than 14. Even though they haven't been put on the SHI, even though you don't have a certification, that's the way the law is meant, that's the way the regulations read. And I think that is the best interpretation I can offer of why those two projects get you over the magic number. And if I could just add one thing that I heard that the chair picked up on. I too, like Attorney Pucci, practice a lot in front of the HAC, and I share his opinion that it's generally not a friendly forum to municipal interests. And one of the benefits of the town having this safe harbor is it means the applicant has to actually convince the board, you, on the merits of their project. Not that we're just going to go through the motions and then go to HAC. We've got to earn your votes. So to me, if there's any reasonable basis under my interpretation to invoke it, that's the right answer for the town's interest and for the board's interest, because you could invoke it and then the chips will fall where they fall. And that's for another day. Don't do it so that you're waiving it for all time, We'll never know what the answer was because there'll be no way to find out. Thank you.
Thank you. Hear from the applicant or counsel for the applicant.
Hi, yeah, it's Andrew DeFranza. Interesting conversation. In this case, I'm the non-lawyer in the group who's speaking. So I'm, for those of you who don't know me at home or otherwise, my name's Andrew and I run a nonprofit affordable housing group just on the North Shore called Harbor Light Community Partners. So I come at this from an ethical and mission-based perspective. It's interesting to hear the discussion. So I think what I would say to you is we disagree with the position of Attorney Murphy and Attorney Hill, partially on the spirit of the intent. I think what you're hearing philosophically is a different posture on the nature of 40B at all, and whether we're trying to actually get something done and advance something, or whether we're trying to stop something. I think the next move here, the decision by the board, certainly affects the tenor of the process that'll happen after. So I disagree with Mr. Murphy's point as to whether it's adversarial or not. I think that's not correct. I think our point here on the ethics front is the spirit of the law. The idea, right now we have this housing production plan. It's a 5-year plan. So it's 19 to 24 on the document, but it's a 5-year plan. And it calls for 14 units a year or 70 in the 5-year period. The previous plans had similar numbers. To my knowledge, we never, as a community, never have met it in a given year. The idea that a project that was approved in 19 and would have counted then can somehow become ineligible for lack of activity and count again in a different year seems to me not to be in the spirit of the law nor in good faith. And so whether or not it legally would be allowable, we doubt that DHCD would accept that. But as a basic level of fairness and spirit of the law, the idea that you could count something twice in 2 different years, in 19 and then again in 21, seems to me to be odd, even though if you could do it. Now, there's a difference between what is legal and what is ethical sometimes, and maybe this is one of those. But we would certainly ask the board, in the spirit of the law, in the spirit of the intent of 40B, which is to create housing, not to block it, that we would not invoke safe harbor. I also would add to Mr. Murphy's point, we have never, to your point about convincing the board, we have never not gotten a 40B approval at a zoning board, and we've never been to HAC. And so our position is that you can do this in a collaborative fashion, but some of that depends on how you start. And if you start collaboratively and with a tone of collaboration, which is why we spent many, many months with the planning board voluntarily before this, just to get feedback from them and from the neighbors. We could have filed sooner. And then this would be moot, but we didn't. We waited and we talked. And so in good faith, I think we're looking for a good faith response that honors the intent of the law and the intent of the projects and their timeline, 19, 20, 21, 22. None of this, of course, happened in 20, which is also a year of the plan where there would have been no units created. So that would be our position, which is certainly more of a missional, ethical flavor and less of a legal can we or can we not, and more of a should we. So we would ask that you would consider that and consider not invoking. Thanks for the time.
Thank you. So I'll ask my colleagues if we've achieved a little more clarity on the issue. Start with David. Well, let me start with Andy. Is your position the same?
My position is the same, and I would just reiterate what I think I heard Attorney Pucci say, which is even if the board decides we have safe harbor, that doesn't mean that we need to invoke it. I think, George, if you could triple confirm that, but I think that's helpful for everyone to go forward.
Okay. Okay, Attorney Pucci agrees with that statement. David?
Okay, so in regards to the permits of eligibility, I understand that we would be eligible to submit them, but we do not have them at this time. So that's an up in the air throw. Understanding Mr. Murphy's point of view, it is safer to do so because it's kind of a use it or lose it option. and I understand Andrew's point of view in terms of his meeting with the board and with the neighbors, which is appreciated. I have worked through my job with Harbor Light regularly, and to address the letters that were sent to the board from people at home. My point of view is that revoking would give us more time to address, one, the issues that were brought up, water shortages that the town faces, and some of the other issues with traffic, taxes, payments. For those of you who are not familiar with Harbor Lights, these are not bad people. They are low income workers. Again, just as it was presented by Andrew, these are, waitresses, waiters, baristas, mechanics, and part of their rent is offset. So in terms of the tax burden that was brought up in emails, Harbor Lights, it is managed like a professional housing complex. It's not just, people running around doing what they want. It is a professionally run complex, if that puts anybody's mind at ease who may be worried. For this, though, I am going to err on the side of safer to invoke the safe harbor to give us a little more time to work with Harbor Lights and to address the issues that the town has brought forth. But I am for continuing moving forward in meeting our affordable housing requirements per the state regulations.
Thank you. Stephen?
I agree with a lot of what David just said. I think that I understand both sides, and I feel as if there's a good argument to invoke, not necessarily out of any kind of bad faith effort or to purposefully set a tone that isn't encouraging, but simply because of the nature of it, that it exists. We have a limited time. Although that doesn't, I don't think that I want to see the hearing delayed. I'm not encouraged by the sound of any of the potential delays by appeals or hanging up the process.
Bruce?
Well, I think, just listening to these arguments again about these two projects, who says the project on Asbury Street, the Habitat on Asbury Street, can't get pushed off another year, and then we're looking at their building permit as their start or certification start. So it's kind of taking the Willow Street argument and moving it to that one, because that one hasn't broken ground yet as far as I know. So that could be delayed, So, so I think it's sort of risky for us to, I feel like it, that we would lose a safe harbor call, but, in light that it does give us a little more time, I'm kind of unsure about it, where I would decide.
Well, I don't know if this will help anybody. I guess what I said before, the fact that it would give us a little more hand is an appealing point. As Mr. Pucci said, there would be a decision, I think we can assume, if the board declared safe harbor, the applicant would certainly appeal, and there would be, DHCD would rule within 30 days, and then the town would have an option to appeal. Speaking just for myself, I can't, assuming DHCD ruled against the town, I can't, it's hard for me to see at this point a basis that I would vote in favor of further appeal, since I think, as I said, I think our overall goal as a town and as a board is to encourage affordable housing. So, that's where I guess where I stand. So, I'm sensing that the sense of the board is, at this point, well, first of all, let me clarify with Mr. Pucci. Is this does this require a unanimous vote of the board?
No,
No. So
majority.
vote of the board. Okay. I'm sensing that the board is inclined to invoke safe harbor for the purpose of protecting any additional rights we may have. If that's an incorrect assumption, speak up now, or I'll.
Bill, is it 2-2 with an undecided though? Did I hear that you were not inclined?
I'm sorry, I didn't get.
Is it really a split vote though? Is it 2-2 with an undecided, as Bruce?
I wanted to, can I interject
Yeah,
on that? Because
yeah, okay.
that's very astute
Okay,
to try to
Mr. Pucci.
hit, it's astute to try to call it like that. I think what you're trying to do, Mr. Chair, is to see where the board is at, just kind of general consensus, and then you're contemplating making a motion. And then,
Correct.
Andy, you're correct. If somebody makes a motion, you need a majority vote on it. If you don't get a majority vote, that motion's gonna fail, and then you could leave it at that, or make another motion. So I would definitely recommend, which I anticipate that you were going to do, is once you have this discussion and see where the board members are generally at, do it by way of a motion, and that
Yeah.
will
Yeah, that
determine
was
where
that.
people are at.
That was my intention, and as I said, my sense is that the board, I should say at this point, the members of the board that would be voting on this, that are leaning towards invoking safe harbor. So if that's, why don't I read this motion, and then we can, if it's seconded, we can have further discussion. I move to declare that denial of the Asbury Commons 40B application is consistent with local needs under 760 CMR 56.03 paren 1 close paren B small b close paren and paren 4 close paren, because the town increased its number of SHI eligible housing units in accordance with the housing production goals stipulated in the town's housing production plan in the 2021 calendar year by 14 units, an increase of the proportion of affordable housing in Hamilton by 5%, and that requisite written notice to the applicant and DHCD be issued accordingly. Moved further that the public hearing be continued to a date and time certain beyond 45 days.
I'd take a vote on the first motion before you get to the second.
Okay, well, is there a second to that motion? No second, then the motion fails. So I guess we have
Yeah.
two options. We can continue discussion, or we can take that failure of that as a indication that the board is not inclined to invoke safe harbor, And I assume, Mr. Pucci, we should take a vote on that, or is it just by operation of law if we don't act? But I mean, so we could just adjourn, and it would be clear that.
You wouldn't be able to just adjourn, because you're gonna need, you have an open public hearing, so you'd need to continue to a date certain, date and time certain.
But we don't have to take another vote.
You don't have to.
Okay.
You could, I mean, you could discuss the meaning of it further. It's up to you.
What's the board's pleasure? We had a motion to invoke safe harbor that was not seconded. Would the board like to continue discussion, or should we take this as an indication that the board is not going to invoke safe harbor, whether it's available or not? Andy?
I'm happy to have a motion to adjourn.
Okay. David?
Seconded till we get a better grasp of where the town lies and its current percentage of what it's produced for affordable housing.
I'm not clear. Are you seconding the motion that I read?
I'm seconding this.
Okay. Okay, so the motion that I read has been seconded. Is there further discussion about the motion?
Mr. Bowler, is there an opportunity for public comment on this?
Brief.
I guess just two comments. Seems like there were several board members who were
Please
inclined
identify yourself.
to...
Is this Mr. Murphy again, or who?
No, my apologies. Philip Blake, 16 Gale Avenue, South Hamilton.
Okay.
Just a couple of, I guess, comments, questions. It seems like there were, it seemed like three board members who were inclined to, in favor of the motion, and then suddenly there wasn't a second. Based on the last comment by one of those members, my sense is that this is a decision that's being pushed out. But as I understand it, there's some time frames by which it has to be made. So is tonight when you have to make that decision, or can it continue to be reviewed?
I have every intention that we will make a decision tonight. We must make it within 15 days, and we're already at, 7 or 8, I think, so.
Yeah, 15 days from the date you open the public hearing.
So my question would be if, my sense is this question is being presented as being pro 40B and pro the project, or anti 40B and anti the project. And to me, as I understand it, the project could very well still go forward, be considered as a 40B project, and I think as the chair qualified it, that you would just have some hand, meaning you would not be ruling on this as presented with no control over the project at all, no ability to condition it, no ability to consider local needs. Or you could go through and review the whole project as a 40B and consider particular conditions to address, particular environmental or traffic concerns that might exist. And it seems odd that a board would give away its ability to in any way meaningfully regulate a project and to consider local needs if it had the possibility of doing so. That seems illogical and contrary to a board acting in the best interest of the town. It seems like he would reserve that, proceed to consider the project, and if it's a good project, it goes forward. There might be some conditions or there might not be, but you would at least have that latitude. Those are my comments. Thank you.
I don't disagree, and I don't think I said that we would. I think we would continue, assuming the motion passes. We would consider to a date certain, which I'll give away the secret. It would be June 1st, and my druthers, however DHCD rules, would be to go forward with hearing go forward with the hearing, because I think that's the most efficient use of the board's time and the public's time. So I'm not suggesting that we put this on indefinite hold, but I think if this motion is voted, we can't really meet and discuss the matter before the DHCD rules. So, does that answer your question?
Yeah, although I think once you waive it, you lose it.
We're not-
As a
The motion
sort of
on
starting.
the floor, the motion on the floor is to not waive it.
Okay.
Ellen Rothman in the upper left hand had a comment question.
Thank you. I'm Ellen Rothman, number 6 Canterbrook. So I obviously have a very personal stake in this. First of all, I just want to say that I'm looking at it from what is the downside of not invoking, and to what Mr. Chairman just said, and others have said, that there's no indication there that you're against the project, that the project shouldn't happen. That in my mind, what it does is it gives the town more opportunity to negotiate and to have conditions. Perhaps this project's a little too large. Perhaps there's too much light. Perhaps there's too much traffic. Whatever that might be, the septic systems. But that it gives you the opportunity to challenge some of what is, and to negotiate without knowing that it might be completely overturned if Harbor Light, if you, for some reason, go against it, then Harbor Light can go and do the full, and not take advantage of your recommendations. Sorry if that's a little, I hadn't thought it through before I actually spoke, but
Well, just
thank
to
you
be,
very much.
okay, just to be clear, however the board votes on this, assuming and then assuming that the board chooses to go forward, there will be ample opportunity for the board and the public to address all the issues. The extra hand that I've referred to is really down the road in the event of there being an appeal after a full hearing and decision by the board.
Understood. I'm just trying to understand the downside of not going forward with the invocation, given that you can still do whatever it is that you would want to going forward with the project. And, because I'm not anti-40B in any way, shape, or form. I have questions regarding the way it's currently designed. And
There'll be
it's my
plenty of
understanding that
if we go
Safe
forward.
Harbor is not invoked, that then we don't have an option. It's either yes or no with no gray area in between.
Well, that, again, that's not the case. I just want to be clear for the public that however the board votes on this matter, there will be a full there will be a full hearing on all the issues that maybe are of concern to the board, the abutters, and the public. Anything else from any other further discussion from members of the board? We have a motion that's been seconded. I'll read it again quickly so we know what we're voting on. I move to declare that denial of the Asbury Commons 40B application is consistent with local needs under 760 CMR 56.031B and 4, because the town increased the number of SHI eligible housing units in accordance with the housing production goals stipulated in the town's housing production plan in the 2021 calendar year by 14 units, an increase of the proportion of affordable housing in Hamilton by 5%, and that requisite written notice to the applicant and DHCD be issued accordingly. That's the motion, which was seconded. Any further discussion? If not, we'll move to a vote. Because some of the voting members are on Zoom, this will be a roll call vote. So we'll start with the members voting on this will be David Parentchief, Bruce Gingrich, and myself. So we'll start with you, David Parentchief.
I vote for utilizing safe harbor.
Okay, aye. Bruce?
I vote for not utilizing safe harbor.
Okay. Bill Bowler, Chair, I vote to invoke safe harbor. The vote is 2-1 and majority vote, so the motion passes. We have a second motion. I move further that the public hearing be continued to a date and time certain beyond 45 days to allow for applicants' 15-day appeal deadline, DHCD's 30-day ruling, and to meet within the subsequent 20-day deadline to determine whether the board wants to appeal a potentially adverse ruling to HAC or proceed with the hearing on Wednesday, June 1st, 2022 at 7 p.m. Is there a second?
I second.
Okay. Discussion, questions? If not, I think we'll go to a vote. Again, a roll call vote. Start with David Parentchief.
Can you say that one more time, Bill? You cut out.
Moved further that the public hearing be continued to a date and time certain beyond 45 days to allow for applicants' 15-day appeal deadline, DHCD's 30-day ruling, and to meet within the subsequent 20-day deadline to determine whether the board wants to appeal a potentially adverse ruling to HAC or proceed with the hearing on Wednesday, June 1st at 7 p.m.
I vote to move on that.
That's a yay.
That's a yay.
Okay. Bruce?
I second that.
No, no, we're voting on it now. Are you?
Oh, yes. Yes, I do.
Okay. Okay. Bill Bowler, Chair. I vote yay. The vote on that motion is unanimous. That's all the business that was before the board tonight, so I would entertain a motion to adjourn. Is there a motion?
A motion to adjourn.
Okay, it's been moved by Bruce Gingrich. Is there a second?
I second.
Okay, seconded by David Parentchief. Again, a roll call vote. David?
I vote to adjourn.
Okay. Bruce?
I vote to adjourn.
Bill Bowler? Aye. Okay, thank you very much. We're adjourned. Thanks, everyone, for your attendance.